this letter, we received typewritten, I guess, report transcript of the PowerPoint photo identification procedures that the police had engaged in with Ms. Mangum on April the 4th. In that transcript was reflected an exchange with Ms. Mangum. We had not yet received video at that point in time of any of this, which we later got, but the transcript reflected that apparently when she observed the picture of our client Dave Evans, that her response was something along the lines of, "He looks like one of the guys who assaulted me, sort of." And then there was a follow-up question about, well, how do you mean sort of? And she said, well, it would look like him if he had a mustache.
After you got that report, did you do anything in terms of responding to that supposed identification by Ms. Mangum?
Yes.
Okay. What did you do?
Well, that was part of this. Well, first of all, there was at the end of that exchange, the officer clarified, so you're saying the person that assaulted you had a mustache? And she said yes. So obviously, we took steps to try to obtain independent evidence that Dave Evans did not have a mustache on the night of March the 13th. We obtained that evidence, and this letter was an attempt to try to communicate that and sit down with Mr. Nifong and talk to him about that.
Okay, and that's in the third paragraph there?
Yes.
Where you say you have indisputable photographic evidence that he did not have a mustache?
Yes.
And what type of evidence did you actually have of him not having a mustache?
A photograph, a digitally time-stamped photo with embedded metadata on either side of that night. There was not an actual photograph of Dave Evans from that night, but there were two photographs that were on either side of that night with embedded metadata, which clearly showed that he didn't have a mustache before or after.
Did you, with this letter, did you provide any other evidence or information that you believe demonstrated Mr. Evans' innocence?
Yes.
And what was that generally?
We provided Mr. Nifong with a copy of a polygraph examination that we had administered to Mr. Evans. As you'll recall, he had offered to the Durham Police Department to take a polygraph on the night of March 16th. They did not take him up on that offer, so we did. And we retained Bob Durdak, who a lot of folks in law enforcement around here in North Carolina and nationally know. He's one of the preeminent experts in the nation on polygraphs and the administration of polygraphs, and we asked him, he's based in Charlotte, and we asked him if he would administer a polygraph examination to Dave.
Okay, and did he do that?
Yes.
And did you set forth how do you pronounce his name?
Durdak.
Durdak. Did you set forth his credentials primarily on page 2 of that letter as to who had actually administered the test?
Yes.
And what his background was in terms of being former FBI and other credentials?
Yes.
And did you provide Mr. Nifong with a summary of the results in the letter?
Yes.
And what generally did those results show?
Well, if I could just read from the letter.
Sure.
Last Friday, April 21st, 2006, Bob performed a polygraph examination of Dave Evans in 2 series. In the first series, Dave was asked whether he was involved directly or indirectly in a physical or sexual assault of the alleged victim in the above referenced matter. In the second series, Dave was asked whether he was or is withholding any personal knowledge of any such assault. He answered no to all questions, and Mr. Durdak concluded that the examination strongly supports the truthfulness of Mr. Evans concerning the relevant questions.
Okay. And did you just summarize the report, or did you actually provide Mr. Nifong a copy of the actual report of the polygraph exam?
We provided him with a copy of it.
And that's attached to the letter in Exhibit 213?
Yes, sir.
After you discuss or convey on to Mr. Nifong the results of that polygraph test, tell me generally what the last 3 paragraphs of that letter that you conveyed on to Mr. Nifong.
Well, we were trying to sum up, kind of desperately trying to sum up the evidence that we believed supported Dave's innocence and the problems that we believe existed with the evidence that we knew up to that point in time being the only evidence that the state would allege establish that he was guilty. So Mr. Cheshire was trying to summarize that in as succinct a way as possible and say, please do not indict our client. He didn't do anything wrong. But if you do, please at least allow him to be afforded the same opportunities that Mr. Seligman and Mr. Finnerty had been afforded after their indictments, which was, bonds and being able to turn themselves in.
And can you just read the last sentence on page 3 of that letter, Mr. Cheshire's letter to Mr. Nifong?
But again, we strongly urge you to refrain from pursuing charges against Dave, and as always, our offer still stands for you to speak to Dave Evans or to us about these issues at any time.
And did Mr. Nifong ever at any point take Mr. Cheshire up on his offer to personally interview Mr. Evans before he indicted?
No.
Did Mr. Nifong or the police officers ever at any point request information or request an interview of Mr. Evans that was refused?
No.
When you got those materials, what was done with them?
Over the course of the next month or so, I looked at them. It became my responsibility. The defense lawyers met over a couple of days in early November. By that time, Jim Cooney had become involved in the case, and all of us met for a couple of days to discuss where we were going from here. And assignments were given, and it fell upon me in the defense to look at and analyze and sort of spearhead whatever it was that we were going to do with the DNA evidence, because again, to be quite candid, the attorneys for Collin and Reed knew that there was no connection whatsoever between their clients and any of the DNA testing that had been done. So it again was sort of my duty to look at the DNA stuff, and that's what I did.
And what did you do to try to understand the information that you got?
Well, I had talked earlier in the summer when I knew that this task would fall upon me, I'd talked to a couple of lawyers in Washington named Rob Carey and Chris Manning, who worked at a firm called Williams & Connolly, and they were very close friends of the Evanses and had offered their services in any way to help Joe and I with Dave and the rest of the kids' defense. And when I had initial discussions with them, Rob Carey said that he could consult with Hal Dedman, who is a former head of the FBI lab and is an expert, and had agreed to make himself available for consultation at some point in the future if we needed him. And I asked Rob to ask Mr. Dedman if a person who knows absolutely nothing about DNA would like to try to find out some things about DNA, where would you send him? And Rob did some inquiries and told me to go to Amazon.com and buy a textbook about DNA. So I did, and I read it, and as I was reading it, I read it in conjunction with looking through these 1,844 pages of documents, and that's what I did.
In that time period over the next month, can you give an estimate of how much of your time you spent going through this documentation?
I can't tell you exactly, but I can assure you it's somewhere in the 60 to 100 hour range. I mean, it's the amount of work that I did to try to figure out what was in these materials and to bring it to the attention of other lawyers and to bring it to the attention of our clients and to try to run it by somebody who knew DNA and to try to put it into a workable report in the form of a motion and to try to provide that to the state of North Carolina and to try to get a confirmation about whether our analysis was correct, easily between 60 and 100 hours.
And did you reach any preliminary thoughts or thoughts after you reviewed the information and studied the scientific documentation about what was in there?
I mean, I reached a conclusion, like what I thought that it showed, and yeah.
And did you communicate that conclusion to anybody else, including other defense lawyers?
I did. I mean, the first thing that I found actually was the pubic hair comb, Section 2 of the pubic hair comb, had what it seemed to me from reading all this stuff and cross-referencing it, male DNA that did not match any of the lacrosse players or any of, which includes the people who were indicted. And I found that after looking at all this, I found it one night, like around 6 or 7, and Joe was still in the office, so I said, I'd like to talk to you about this, and what do you think about this? And I think he kind of thought that, he said, that's interesting, but, we need to make sure that's right before we do anything with it. And I called Jim Cooney, who, was involved in the case at that point in time and who knows far more about expert testimony and science than I do. And I said, Jim, I think I found foreign male DNA that hasn't been reported to us and doesn't match our clients on the pubic hair, on one section of the pubic hair comb. And Jim had much the same response, which was, because, you have to understand, we had all been in court all summer and fall being told that there wasn't anything that was found or discussed in these meetings with Dr. Meehan, that hadn't been reported to us. And so everybody down the line, and then, of course, I sent an email to Doug Kingsbury, and I said, Doug, I think I found male DNA on one of the rape kit items that doesn't match the lacrosse players. And his response was the same thing. Wow, we really need to run this by a DNA expert before we do anything with it. And then over the next couple of days, it just kept getting worse. I mean, I would find another one of the items that had male DNA that excluded our clients and their teammates, and then another, and then another, and then another. And so what I did at the conclusion of that process was I drafted probably about a 40-page memo about it that cross-referenced all these materials and circulated that to the defense lawyers. And I called Rob and Chris in D.C., and I asked them for a meeting with Hal Dedman, who was the DNA expert that they had available. And they said, okay, and set up a meeting for December the 8th. And I flew to Washington, and I met with Hal Dedman and Rob Carey all day on December the 8th, and we went through, Hal had an opportunity to review my memo, and we went through some of the materials, and we talked about it, and at the conclusion of that meeting, he essentially confirmed what the analysis was, and I communicated that, immediately called Joe and told him, and then we set up a meeting for the defense lawyers to talk about this. I think I called Jim also, and then we set up, I called the Evanses first, and then I called Joe, and then I called Jim, and then we set up a meeting to talk about it and agreed that what we needed to do was convert this information to a motion to compel production of additional discovery materials. And said nothing during those meetings beyond what was encompassed in the final report of DNA security dated May 12, 2006. The court accepted Mr. Nifong's representation about those meetings and held that there were no additional discoverable statements by Dr. Meehan for the state to produce, transcript 24 to 29.
Okay. And did Mr. Nifong respond to your draft order that you sent him on October 19th?
He did.
And did he respond by telephone or some other way?
Well, he initially responded, if memory serves, by telephone.
Okay.
He called my office the next afternoon, I think it was, October 20th, which would have been the deadline for providing these materials to us.
And what was his response in that telephone conversation?
I think that he had told me that he just recently received the DNA security materials, that they were in his office, that they were very voluminous, that he really didn't know what he was going to do to get it all copied, and that it would be sort of a difficult task. And I think we discussed a couple of the other issues related to some other outstanding discovery things related to receiving digital data. And at the conclusion of that part of the conversation, I told him that I might be able, because he was really voicing concerns about getting it done and how much it would cost and such, I told him that I would check with the other defense lawyers to see if maybe we could receive a single copy and make copies for each other, just so that it would expedite and facilitate the whole thing.
And how did that conversation end with Mr. Nifong?
Well, I thought the conversation was over at that point in time, but Mr. Nifong then brought up a letter that Mr. Cheshire and I had sent to him regarding other discovery issues that had come up in the intervening period of time, and he got extremely upset with me about that letter, and said we weren't acting in good faith as lawyers. He wanted to know why we were always accusing him of withholding information, and wondered why defense attorneys always accuse prosecutors of withholding information. I think he said that every defense attorney that he's ever known that comes to his office to work with him always has those thoughts, and one would wonder why you would think people are hiding things from you. And I tried to explain to him what some of our concerns were about the discovery materials being withheld, and he sort of at the end of that exchange, just his volume kept going up and up and up. He wouldn't let me respond in any way, and he finally hung the phone up on me.
Were the discovery issues addressed in that letter, were they related to the DNA information or some other type of information?
They were related to conversations that he had with Crystal Mangum that had not been, the substance of which hadn't been reported or provided to us.
So what I'm going to do is go through some of these statements, and I'm going to be asking you if these are consistent with the standards of practice for prosecutors in North Carolina to make statements like the ones we're going to go through. And the first one is, quote, and one would wonder why one needs an attorney if one was not charged and had not done anything wrong. And the next one I'd like to ask you about is, well, frankly, quote, well, frankly, I'm disappointed. I understand that it's likely they're doing it as a result of the advice of counsel, but although that might be good legal advice, I don't think it's good moral advice, end quote. Are those statements consistent with the standard of practice for prosecutors communicating with the media in North Carolina?
No, ma'am.
And how do they deviate from the standard?
The rules specifically prohibit us in talking about one's exercise of the rights to counsel, which under the Sixth Amendment, and their right to remain silent under the Fifth Amendment. And I believe, once again, one of the rules directly says that we cannot comment on whether or not a defendant did or did not make a statement. If you were at trial in a closing argument, so to speak, talk about how the defendant did not make a statement because he either chose to remain silent or he asked for a lawyer, that's grounds for a mistrial. So you can't even say it in court in front of the jury, and if you can't say it there, you certainly can't say it outside the courtroom.
Why can't you say it outside the courtroom? What's the harm?
Because you're commenting on their exercise of their constitutional rights.
Is it consistent with the standards of practice for a prosecutor in North Carolina to say to a representative of the news media, quote, I would like to think that somebody not involved in the attack has the human decency to call up and say, what am I doing covering up for a bunch of hooligans, close quote?
No, it is not.
Okay, and how does that deviate from the standards that prosecutors employ in North Carolina?
I think implicit in that remark is that you think a crime has been committed, which is once again expressing a personal opinion, and I don't believe you can do that. And calling a defendant or a potential defendant a hooligan is improper. And to talk about someone's duty to come forward if there is in fact no duty to come forward is improper.
Let me have one more, please. And let me just ask you about a couple more questions, a couple more statements. First of all, can a prosecutor, is it consistent with the standards of practice for a prosecutor to make comments about a crime being allegedly racially motivated?
I do not believe so, no.
Are there any circumstances you're aware of in your experience as a prosecutor where it would be appropriate for a prosecutor to assign a racial motive to a crime in an attempt to try to calm anger in the community or prevent racial unrest?
Objection. Sustained.
Well, let me ask you about a couple of these questions, these statements specifically. Quote, the thing that most of us found so abhorrent and the reason I decided to take it over myself was the combination of gang-like rape activity accompanied by the racial slurs and general racial hostility. Close quote. Every rape is a serious case, but some speak to the community in a different manner. This is one of them. The racial aspect is particularly abhorrent. Close quote. Now, are those statements consistent with the standard of practice for lawyers practicing in North Carolina as prosecutors?
No, ma'am.
And how do they deviate from the standard?
Once again, it's expressing a public opinion that a rape occurred, and I believe the description of how the rape occurred would tend to heighten the condemnation of anybody that is charged in the future with that crime.
So that would apply whether there is already an accused identified or not?
I would think so, particularly in context of this case where I believe statements were made that a rape had occurred, that it had occurred at this residence, and the only people that were there were lacrosse players, so they knew that the eventual suspect was from that very small group of people.
Let me ask, can you show Exhibit 145, please, on the video? It's going to come up here behind you on the screen. If you would watch that, please.
District Attorney Mike Nifong.
I have not accused anybody of committing this rape. I do believe that a sexual assault occurred. When I looked at what happened, I was appalled. I think that most people in this community are appalled.
Defense.
Okay, and also if you would show video Exhibit 147A, please.
Mr. Nifong. Well, I'm not going to surprise anybody here. I would not change anything about the way that the current district attorney handles the situation.
I can't hear this.
No.
I have handled the situation the way the situation should have been handled. I appreciate the fact that Ms. Black acknowledges that I'm the only person up here who knows what the facts of the case are. And I also appreciate the fact that it's very difficult for anybody to respond to a question about how you do something differently when you don't know what it is. Although Mr. Bishop the other night at the Democratic Party Forum said that if he were the DA, everybody would already be in jail. He didn't say who. He just said everybody. And of course, if you arrest everybody, it's a lot easier. I mean, I guess the idea is to put everybody in jail, we'll sort it out later. And there was pressure put on me to do just exactly that. And there was also pressure put on me to do nothing. To say, well, you know, her profession was not really the most honorable in the world, and we really don't have the strongest case in the world if there's no DNA, so let's forget about it. Well, ladies and gentlemen, that's not doing your job. If I did that, then you should vote against me. I would vote against me if I'd done that. Because that's not what this job is about. The reason that I took this case is because this case says something about Durham that I'm not going to let me fit. I am not going to allow Durham's view in the mind of the world to be a bunch of lacrosse players from Duke raping a black girl in Durham. And you know, here's the other thing. There are 46 members of that lacrosse team at Duke who gave DNA samples to be tested. And there weren't 46 of them that did this crime. It is just every bit as important to find out who is not responsible. And to let them leave Durham without that cloud hanging over their head about, my goodness, look at that, he used to be a member of the Duke Lacrosse, he must be a rapist. That is also not acceptable. The only thing I really said about this case publicly is that, based on the medical evidence, I believe that the woman had been raped.
Now, you just saw the 2 videos. Are the comments that were made by Mr. Nifong on those videos consistent with the standards of practice for prosecutors in North Carolina?
Not all of them. There's some of the things there that I didn't have any problem with him saying.
Okay, which ones did not comply with the standards?
Talking about how lacrosse team members have raped this woman. That's expressing an opinion as to who did it and that they're guilty. And then adding into that the race element.
And what's the problem with adding in the race element?
Well, once again, we're talking about pretrial comments, which of course I've said in general you shouldn't be doing. But when you add in the race element, it would tend to heighten the condemnation of the general public about whomever committed this offense. It is bad enough that you have a rape, bad enough that there's an allegation of a gang rape, but if you add on top of that it was a racially charged crime, or the allegation that was, of course people are going to condemn the person who they think did that.